She has got experience over 10 years in property law, wills, estates, commercial law, and many other part of the law. But today she's here with us to talk about her knowledge and share her knowledge in property law, and to chat some of the pitfalls to look while going through a contract of sale. So thank you, Jenny, for joining me.
Thank you, Sanjeev, for the opportunity today to join you in the information session. It's my pleasure to be here to do this with you. Yes, as you mentioned today, I'll be talking about what is property law, and more specifically, conveyancing, the standard process, the expectations for our clients to look out for, the type of ownership structure for them to consider, and the types of title that they'll take on if they buy a property. And we'll have some time to go through some tips to consider when they're buying property in each state. And towards the end, I'm open to take on any question sessions to answer any common questions that tend to come up, or any case studies that we want to raise. So firstly, I'd like to talk about, what is conveyancing and the role of a solicitor. Okay, so conveyancing is the process of transferring legal title from one person to another. That's basically what that is. Now, a conveyancer is only permitted to practice conveyancing. It cannot practice other areas of law. So it is very important for, in situations where a property transaction ends up being in dispute, it's actually very important that the parties have a solicitor to assist them in dispute resolution. So it's very important, I believe, that having a solicitor involved from the start is probably the best case scenario for the client. And, as practicing in property law for many years, our team has many experience to act for first-time buyers, investors, developers, off-the-plan contracts, complex property sales, including on sales and acquisitions. So matters can be just as simple as buying, their first home. It could be an investment that involves many people where the vendor isn't even the owner yet, or it involves many other parties. So it gets very complicated. But the idea is that if, our clients come through with the right expertise and professional team, they're basically looked after. We have a lot of experience looking after clients from different cultures and with different levels. So we specialize in providing legal services to each of our clients at their level, so that they can understand their legal rights and obligations under the contract. So we're really good at simplifying complex legal terminology and processes to basically simplify that for our client to understand that very easily without causing too much stress in their process. Because as you would know, most people, signing a contract for sale to buy something is generally the most important and biggest financial decision that they do. So it's very important that they know their rights and to avoid any long-term consequences. So it's very important to have a skilled and experienced solicitor acting for a buyer to manage the file when things are going well, as well as when things are going wrong. Okay.
You know what, Jenny, to add upon, and that's why I recommend all my clients that even a lot of people ask me, like, Sanjeev, would you recommend a conveyancer? Because, we are transacting, conveyancer can be a little cheaper, but I say, there's so many complexity, we wish that the transaction goes smooth, but when there is a complexity, or maybe, we need to understand more, that's why, have a solicitor from day one. And it's good to have on this side, because, things can be tricky. I work closely with you, and we see a lot of the cases, right, where it's so much good to have someone like yourself to resolve this thing. So yeah, that's why I recommend all the time my clients that.
Sometimes it does involve us writing, using the legislation, actually defending our client in the potential claim, and to avoid potential claim. And most of the time, parties just compromise on the issues and just settle the matter. So there's many things that, with the experience, we know what can happen in a file. So one of the most common problems in a conveyance file is when the lender isn't ready to settle, and what happens then. So that's a very common problem in many files. It's not the client's fault that the lender isn't ready, nor is our fault, but it is an issue that we have to try to manage, which may involve, negotiating with the other side to extend the settlement with little cost to our client. So at the end of the day, the contract isn't terminated, and that we end up having a client owning the property without any claims or issues. Yeah.
That's true. Yeah.
Yeah. So moving over to talking about the process conveyancing. So a lot of times when people come aboard, they get a bit overwhelmed that there's so many things going on. They're talking to their buyer's agent, they're talking to the real estate agent, their lender, their solicitors. There's so many parties involved, and they get really overwhelmed about what's next. So generally conveyancing goes over a period of 4 to 6 weeks, okay? And it's a step-by-step process that we guide them through start to end. Generally, I guess if I was to summarize what these steps involve, I would say, firstly, a buyer will find a property, generally through a buyer's agent like yourself, Sanjeev. And once a contract is signed, the agent will forward the contract that's dated to each party's legal representative. So from here, a legal retainer is established, and our team can then start work and manage the file from start to end. Now, when the contract's under contract, we manage the buyer's critical dates, such as their cooling off date, their building and pest date, deposit due date, stamp duty, and most importantly, the settlement date. Okay. So basically, our initiative is to make sure the process is as smooth as possible. Okay. And having solicitors involved in the process, basically, there's little to no risk of fraud, because what happens on the day of settlement is we use a quite secured clearinghouse system where on payment of the balance to the seller, the buyers become the simultaneous legal owner of the property. And that's what people want to know. Okay. Moving along, we can talk about the types of ownership. So when there's more than one buyer in the contract, they can choose how they want to own the property for the other buyer. And the first and most common type is called joint tenants. And this is when two parties own the property 50-50. And if one party dies, the other surviving partner will automatically inherit the property. So this is a very common structure for husband and wife investors and owner-occupier structures. The other type of ownership is called tenants in common. Okay. In tenants in common structures, if one party becomes deceased, the surviving partner does not automatically inherit the estate. What then happens is if they own the property, for example, 60% and they passed away, then that 60% will be allocated under their will and administered under probate and succession law. So sometimes people use tenants in common because they buy it with a business partner who's not a family member. So they would like to know if something happened to them, then their share goes to their family. Okay. So when buyers go through this process, we ask them and we tell them the pros and cons of each, and they choose how they want to own their own ownership. Okay. So moving along, I like to talk about some tips when buying a property and what clients should look out for. Property law is different every state. It's not a federal law, hence it's very important that a buyer understands how each state works and to get the best advice every time they're buying a different state. Now, today we will talk about and focus probably on New South Wales and Queensland for the purpose of the information session. And I'd like to start off with talking about New South Wales. Okay, so in New South Wales, for a contract, basically for property to be legally marketed, the agent needs a contract for sale, and a vendor in New South Wales has a high obligation to ensure that they have sufficient disclosure documents, which are court described documents under the legislation, to ensure that the contract has all of the mandatory documents for a buyer to have a look at. Some of these mandatory documents that a seller has to provide include the title search, the deposit plan, the zoning certificate, any easements or the restrictions related to the property, any certificate of non-compliance, a homeowner warranty insurance if the house is still new, and possibly the occupation certificate. Okay. And in New South Wales, when the buyer does sign a contract and they're within their cooling off period, this is a very important time for buyers to finalise their research and due diligence to make sure that their finance is approved and any building and pest reports are satisfactory. Now, once the contract passes the cooling off period, a contract becomes unconditionally binding. What that means is a buyer cannot change their mind, okay, without consequences and costs. So, generally, if a buyer commits to a contract, they have to understand that they may be losing a holding deposit during the cooling off period, and that's a statutory right that the vendor has if a buyer signs a contract and decides not to proceed further. Quite rare, but in New South Wales, sometimes the vendor does agree to special conditions such as the contract being subject to finance and an inspection report. So if that is agreed upon, we will manage those critical dates and ensure any terms that are agreed to are in the written contract, and we make sure we take any necessary action to end the contract correctly if we are instructed to do so. In Queensland, things are a little bit different as well. So the Queensland contract is not as detailed as the New South Wales contract. That's because the law just isn't as strict, where the seller just needs to give very basic information to a buyer. So what does that mean for our clients? Okay, our client must make sure that when they're looking at a Queensland property, that they are to make their own inquiries about the zoning or easements of the property, or find out the history of the building or past non-compliance issues or anything else in there, because the seller will not provide this information in the contract. Okay, so sometimes our buyer that's looking at property in Queensland may come on board and they'll let us know they plan on developing on the land in the future. And what we tell them is they should look at speaking to the relevant council or town planner to find out more about the current development regulations and whether there are any other development considerations to factor into as part of the buying process. So a typical one may be if the area is more flood prone, sometimes council makes people raise their land or have the sloping of the storm water particular way. So these are things that a buyer needs to consider if they want to develop on the property. But at the end of the day, when the buyer comes through, they go through Sanjeev, and you would do all of the due diligence for them. And they generally come back to their legal representative to say, yes, their buyer's agent has done a portfolio on the property to explain all the risks and characteristics of the property for the client to understand and accept. Okay. I think another main difference in Queensland property is that the risk of the property does pass to a buyer once they are under contract, but not the owner of the property yet. So this is something that can come up if there was a damage to the property and there's a dispute over who's responsible. So to mitigate that risk, our primary advice to clients buying in Queensland is to purchase insurance for the property to basically not go through the stress of if there was a damage once they're under contract. The other thing I want to talk about is generally the type of title when people buy property. So the most common one people know about is freehold title. Okay. So most homes are freehold title. That's basically when a buyer gets ownership of the land and the buildings on that land. Okay. What's less common these days is leasehold. A leasehold means when a buyer has, ownership of the land and the building on it, but only for a certain period of time, such as a leasehold for 99 years only, and after that it reverts back to the government. The other common type of title is called Strata Title, which is generally applies to apartments or townhouses, and this gives the owner the right to the internal parts of the property. Company title is less common these days, where a buyer will buy shares in the company, and being a shareholder would then entitle them to use part of the apartment. And the last type of title that you may see is called a community title, where it's sort of like a combination of strata title on large developments and gives the buyers the right, along with other owners, to own common land, such as the communal barbecue area or tennis court of the estate. That's an example of a community title. Now, it's quite interesting that, property law is fastly emerging, where the government is keeping up with the market, where there's a lot of demand for, basically more apartments getting built. So there's more regulation regarding builders' requirements, as well as, there's talks in New South Wales of a stamp duty reform. Okay. The New South Wales government is looking at reforming the current stamp duty system, yet to be legislated. So when that new legislation does come out, I'll be happy to, inform our audience on what that new stamp duty regime will look like to them, in terms of, do they pay a lump sum stamp duty today, or would they opt in to pay property tax each year if they, for example, don't plan to keep the property for many years at all. So that's quite interesting to see how what our government's going to do soon to basically reform the system for basically under property law.
I think that's a big change coming in, right?
It is a big change. Yeah, because in the 1980s, that's when they basically introduced capital gains tax, and that kind of changed the way people do. They quickly sell everything now just to be under the what you call grandfather legislation, or before the new regime commences. So it's quite interesting how it plays out and how it affects the property market prices. So generally, every time the government increases, stamp duty thresholds or any basic concessions to buyers, it does tend to drive up the prices in the market and the demand. So it'd be quite interesting to see how it plays out for everyone. So yeah, from here, I hope I have given the audience a better understanding what is conveyancing, and the important role of a solicitor in the process. Every contract is very different, and my best advice to everyone is to ensure they have quality legal advice behind it all, and that way the process can be as smooth as possible. Sanjeev, do you have any questions today you like to ask me that tends to come up with our clients from time to time, or anything you want to ask?
Yeah, I do have a few questions, Jenny, for you. So I think, but no, I agree with you that like when people are buying property, it's one of the biggest item they buy in their life, right? It's a quite big amount, right? So I think it's good to have a good legal team on their side, especially like say even after buying, like depending on if they're buying on a common tenancy or something, then the will might come into the picture, because life is fragile, right? So you see, few points I wanted to check is like say I think you mentioned about different laws for New South Wales and Queensland. Now say if clients choose to cancel the contract during the cooling off period, then I think in New South Wales they lose 0.25%, right?
Yes.
What happens in Queensland? Like, is it a set amount or?
Yes, in Queensland, they would also lose 0.25% of the price. So a lot of the times when the Queensland buyer enters the contract, they end up paying at least $1,000 or $2,000, which normally is equivalent to that holding deposit. So the same rules on the cooling off period applies, where if the buyer changes their mind for any reason at all, they can still cancel the contract. So they don't have to give reason, okay? But they will lose their holding deposit unless, the vendor seller agrees to refund it in total for any reason.
So that's a good point, right? Like, say, sometimes we pay, like, say, $10,000 as a holding deposit in Queensland, yes, or say even 5%. So, like, are we relying on the vendor to refund that whole amount, or it would be like a flat 0.25% in Queensland as well?
Yeah, so it's in the legislation, also in the contract, that only 0.25% is forfeited. So if our clients paid $10,000, which is more than that 0.25%, what happens is the solicitors would write a letter to the agent, who's generally the deposit holding party, and authorize them to refund the buyer their money less than 0.25%. So just because our clients paid more than the holding deposit does not mean that they've lost that money.
Okay.
This is basically during the cooling off period. If they were to, breach contract past a critical date, then the consequences are different.
Okay, definitely. Okay, now thanks, Jenny. I think you mentioned about the building and pest inspection, like the clause we have, right? And we see sometimes, and especially I think recently we're talking about the Queensland one, where, you reminded me as well that now we need to be a little cautious on that. So yes, do you want to highlight on that, like how it is, if we are walking away based on the building and pest clause in Queensland, then what are the key things we need to
yes,
look after? Yeah.
I think the most important thing to understand is when the Queensland contract is subject to building pest clause, the buyer still has an obligation to be reasonable when they exercise their powers to cancel the contract under that way. So, for example, the law talks about the buyer being reasonable, that they have to basically have a written report to show that there's a structural problem with the property. So if there was a structural problem with the property and the buyer has a written report on that, they can then serve that written report to the seller to say, I am exercising my BMP condition, and I am confirming that I am not satisfied with the state and condition of the property because there's a major defect. Once there's a written report to confirm that as the supporting evidence, the contract will be terminated and the buyer will get a full refund. Okay. So I guess what's important is a buyer needs to understand that the standard building and pest condition is only to reflect serious problems with the property. So any minor cosmetic defects are generally not allowed or reasons to be getting out of the contract, unless there's a additional special condition to state that the buyer can get out of the contract under their building and pest report for any reason to their absolute discretion. So that type of contractual term is something totally different as opposed to the standard, common law understanding that the buyer has to be reasonable and it only basically reflects major defects. Okay. Now, and they have to have a written report from the qualified inspector to confirm that as well, because otherwise, it's very hard for the seller to understand and accept the reason why the buyer is not proceeding.
True. How about if there is a major defect? Because one is a structural, another is major, and then minor, right? So with the major defect, still we can walk away if we just putting, say, a building and pest for 7 days?
Yes. So provided it is a major defect and the report specifies why it is major, okay? then that will be sufficient evidence to support the why the buyer is not proceeding. So having a detailed inspector's report to describe the defect is very important, because solicitors are not building specialists, but we use the evidence to support why the client isn't going ahead. Yeah.
Okay. No, that's good. I think, in New South Wales, we say, satisfactory building impest, which means if I'm not satisfied, I think you can walk away.
Wordings in contract is so important. So if our client had a building impest provision in New South Wales, commonly I would negotiate that the building impest has to be satisfactory to the buyer's discretion. So that basically means our client is saying, I don't like the report, I can get out. That's basically what allows them to do.
Yeah.
In Queensland, in their standardised contracts, they do have a standardised building impest clause already. So those work differently unless the buyer has requested for special rights, basically in the contract, for them to go further and have more reasons to end the contract. Okay.
No, thanks, Jenny. I think that's helpful. Now, I think you mentioned about the insurance part, right? Like, say, I know in New South Wales, we have, the insurance is required from the time of settlement, and most likely the clients will get the insurance beforehand, because most of the lenders ask for it anyways. But in Queensland, I think we mentioned that once the contract is signed, get the insurance as soon as possible. So why it is like, because a lot of the clients ask like, oh, Sanjeev, we still have billing impest for another 14 days, and we have 5 days cooling off period. So why we need to get the insurance even during the cooling off period? So what is the reason behind that, Jenny?
Okay, so in New South Wales, you're right to say that the risk of the property doesn't pass until the day of settlement and the change of legal ownership has happened. So it's quite interesting. Yesterday, I had a situation where New South Wales under contract, and there was a fire overnight. And it was very unfortunate for the current owner, but the law is that it's not the buyer's responsibility, and the current owner is now left with those damages. In Queensland, it's a little bit different, where the risk of the property does pass to the buyer about 1 business days after the exchange date. So a lot of the times, the buyer under Queensland transactions do have a building impest clause. Again, the building impest clause allows them to get out of the contract for, major defects and structural defects. So what happens if there was a minor defect, or if there was a damage by the tenant that still costs money, okay? And the buyer may raise that with the seller, and the seller may say, well, these risks is now your risk, okay? So if the buyer had insurance when they are under contract, then it's a peace of mind that if something was to go wrong, insurance is there to protect them. So yes, for extreme major problems, our client, as the buyer, can use the building impest clause to say, well, there's now a major problem, a structural problem. I'm now terminating the contract under my building impest clause. Sometimes there's other types of defects that are maybe are in dispute that is not major, it's minor, okay? But it's still costing someone still needs to pay for the damages at the end of the day. So because insurance is probably going to be paid anyway at some stage, I tend to recommend a buyer to get the insurance, basically after their cooling off period under the Queensland contract. And most insurance policies allow a 14-day cooling off period, where if they cancel the premium, it's fully refundable. So most of the time, the timing of this, if the buyers pass their cooling off period, their building impest due date's probably 10 business days later most of the time. So if they got insurance and they didn't go ahead with it, it's likely that money will be refundable by the insurance provided anyway, but at least the peace of mind that the insurance is now covered and the commencement of the cover has started. So
I agree. I think it's no point getting into the legal fight while you can protect through the insurance, right? Just in case something happens. Because it's all estate law, right? We have for property in Australia.
And
so.
if the property has a tenant in there, then I guess from and at some point the client needs to also consider having landlord insurance for loss of rental and all that sort of stuff. So I think insurance plays a lot of important part in our lives now. The client is outlaying some money to acquire an investment property, and they need to ensure that that asset is protected if something was to happen. Not like my client, yesterday when they had that fire, she actually didn't renew her insurance. So it's a very bad timing where she decided to not renew her insurance because she's about to sell. And it's very unfortunate that the fire happened while under contract. So she took that risk to not buy insurance. And the advice now is that, she has to bear the cost to, restore the home out of her own pocket. Yeah. And that could be quite distressing to hear. And that's what people plan to do. So insurance premiums are, generally tax deductible part of their investment portfolio. So, it's very important that our clients think about having sufficient insurance for their investment portfolio, I guess.
Yeah. No, I agree. I think insurance is one cost which we want to get the best, and always pray we never had to claim that.
Yeah, it's a peace of mind, right? So you think, how do you value insurance? People don't think about that. But then once something does go wrong, everyone's thinking, can they make a claim through the insurance provider? And
No, I agree with you. I think I educate my clients that it's all cost of doing business when you're buying an investment property. So one last question, Jenny. I think you mentioned about that a vendor doesn't provide much information in Queensland in the terms of the contract, right?
Yes.
As a buyer, can we request the vendor in Queensland that I need couple of information, and are they obliged to give that information, or it is?
Right. So what will happen is if our client's already under contract, then we may seek an extension of the cooling off period to allow sufficient time for the turnaround with, the local council if we're ordering something through them. Because sometimes the council's turnaround time may be, up to a week. So we'd like to extend the contract diligent period to cover further reporting sessions. So sometimes we may need an authority from the seller to order such reports, but generally a lot of the reports can be obtained by a third party. So we basically get instructions whether the client wants to carry out further information research, and then we make sure that the contract is allowing sufficient time to accommodate what they're doing behind it all. So that's how we would manage that, because unfortunately the council reports don't come back within 48 hours. Most of the time they take up to a week. So we basically extend, we just extend the cooling off period out. If the building pest reports aren't done in time, we extend that out. If finance isn't done, we can extend finance date. If something else is going on, we can extend the settlement date. So every file is different. And we just basically listen out with our client to understand what is going on, what they'll like to do, and we make sure the contract is accommodating them for what they want to do.
Awesome. Now, I think that's all, Jenny. Thank you so much for your time. I think I'm sure it will add a lot of value for the audience who is going to watch this and listen to your sharings. So I think I know you do all the legal matter in other states as well, Victoria, Adelaide, Western Australia. So I think maybe in another session, probably we can talk about the other states as well, because one session is not enough. And but I think so. Now all good. I think Jenny. So I think anyone watching this, in case you want to reach out to Jenny. She's one of the best in the industry. I think I'll put her details as well. Otherwise, once again, thank you so much, Jenny. Have a good day.
Yeah, thank you so much. Bye, Sanjeev.
Bye.